So can you give me a thumbs up? We're ready to start. Okay. Hello, everybody. My name is Steve Cragg, and as chair of the Bar Human Rights Committee of England and Wales, on behalf of the BHR Executive Committee, I'm delighted to welcome you to today's virtual launch event. It's an event for the launch of our new Guantánamo trial observation report, written by our treasurer, Jodie Blackstock, after observing on the ground in Guantánamo the important case of USA against al-Rahim al-Nashiri. The report is launched today, and there'll be a link for it in the chat. It's not there now, it will be there very shortly. The Bar Human Rights Committee is an independent international human rights arm of the Bar of England and Wales. In 2019, BHRC became the only UK-based organisation to be granted official observer status for the ongoing trials in the military commissions. We've long kept a watching brief on the use of the detention facility at Guantánamo and procedural developments in the military commissions being held there. So far, BHRC has observed 2 cases at Guantánamo and has expressed serious concerns that these proceedings demonstrate fundamental flaws and departure from fair trial norms. I'm keeping my introductory comments very short this evening, as we've got a lot to get through and many great speakers to hear from. The format today is that we'll hear briefly from a number of speakers about their experience at Guantánamo, and then we're going to get into a Q&A session with some of the leading lawyers involved in the process. We've got some planned questions, but we also hope that we'll have some time for some questions from you. Please ask your questions using the Q&A function throughout the event, and we'll do our best to put those to the speakers. First of all, I just want to run through some introductions for our contributors at this session. I'm going to start with J. Wells Dixon, who's a senior staff attorney at the Centre for Constitutional Rights, where he specialises in challenging unlawful detentions at the Guantánamo prison. Wells represents clients in federal court, before the military commissions at Guantánamo, and in various international proceedings. Among his clients are Majid Khan, who was transferred and released in Belize this year, who was imprisoned and tortured in secret CIA black sites for more than 3 years before he was transferred to Guantánamo, and David Hicks, an Australian citizen and one of the first men taken to Guantánamo after 9/11. We've got Alka Pradhan. Alka is an expert on the application of human rights and humanitarian law to counter-terrorism situations and the impacts of torture on fair trials. She's currently Human Rights Counsel at the Guantánamo Bay Military Commissions, representing one of the defendants in the capital case of the United States against Khalid Sheikh Mohammed, the 9/11 case. There's also a defense attorney at the International Criminal Court. She was previously counterterrorism counsel at Reprieve US, where she represented a number of Guantánamo Bay detainees in litigation involving habeas corpus claims and conditions of detention. Alka is also one of the drafters of the Mendes Principles, a new international protocol on the conduct of non-coercive investigative interviews. Carol Rosenberg. Carol is a Guantánamo Bay correspondent at the New York Times. She's been covering the US naval base at Guantánamo Bay, including detention operations and military commissions, since the first prisoners were brought there from Afghanistan in January 2002. Carol has logged more time at Guantánamo Bay than any other reporter and is frequently cited as the authority on the detention operations that were born after the September 11th attacks. The American Bar Association awarded her a silver gavel for her military commissions coverage. A former foreign correspondent, she's covered war, peace, politics, and popular culture in the Middle East from 1987 to 1994, and later travelled frequently back to the region. Tony J. Natale. Tony is a lead capital counsel for the defence team representing al-Rahim al-Nashiri, the individual charged with masterminding the bombing of the USS Cole. Previously, he was a supervising assistant federal public defender in Miami, Florida. Tony was also the training coordinator for the Federal Defender Office and the CIA panel lawyers for the Southern District of Florida. Jody Blackstock is a public law and human rights specialist with extensive experience in justice system reform through policy research and strategic litigation. She's a practicing barrister at Garden Court Chambers in London. She's treasurer of the BHRC and was previously the legal director at Justice. In October 2022, Jody observed the United States against Nashiri case at the Guantánamo Bay Military Commissions for BHRC, and the report that she has authored is the one that we are launching today. And Amanda Weston KC. Amanda is a leading public and administrative law barrister at Garden Court Chambers in London. She co-authors Judicial Review, a practical guide, and is a member of the A panel of preferred counsel who act for the Equality and Human Rights Commission. She was formerly a member of BHRC's executive committee, and in 2020 visited the base to observe the United States against Khalid Sheikh Mohammed case, the 9/11 case, and Amanda deals with closed material procedures in national security cases in the UK. So those are our speakers, our contributors for this evening, and I'm going to move straight on to Carol Rosenberg, who's going to provide us with a brief history and overview of the camp and the military commissions. Thank you, Carol, and good to see you're with us.
Seems to be working. You can hear me?
We can hear you.
Since the prison at Guantanamo opened in January 2002, 780 men and boys have gone through that prison. 30 remain. All of them were brought there by President Bush, and 780 men and boys were brought to Guantanamo Bay. Of those 780, 18 have gone through or are currently in military commissions. 18 human beings. Of those 18, 9 are currently in proceedings. One could argue 10 are in proceedings, but of those 18 who were convicted or currently in proceedings, 2 of those men are currently serving sentence. And that's because Guantanamo Bay Prison was set up not for war criminals, but for what the United States decided to consider after the 9/11 attacks to be war prisoners. Men who were not accused of crimes, but accused of being the enemy, of being put on the other side, of being captured as members of the enemy or the other side. And specifically, they define the enemy as members of al-Qaeda or the Taliban. And it's important to understand this because when we're talking about military commissions, we're talking about an incredibly small subset of the men and boys who are brought to Guantanamo Bay. And what we're talking about is that court that was created for that subset of men and boys. And I know I'm talking to lawyers, but just in case, the difference between a war prisoner and a war criminal is if I meet you on the battlefield, and this is a very much a layman's explanation. If I meet you on the battlefield and you're the enemy and I capture you, you're a prisoner. If I capture you wounded and then I shoot you, I am a war criminal. The distinction is how you treat and behave in the context of that war. So at this court, the allegations are against men, not boys at this stage, men who are accused of committing war crimes that the United States considers to include terrorism. And the lawyers will explain to you why that's problematic, and the lawyers will explain to you how that court came to be. But what I'd like to do is explain to you the background of this. The first case, Guantanamo, ended in a guilty plea by an Australian man named David Hicks, who pleaded guilty to war crimes, as they were defined at the time, went home, completed a sentence, and had that conviction overturned. So of the 9 or so men who have been convicted of war crimes, 2 of them are currently serving sentences, one in Saudi Arabia, but 3 of them have had those sentences overturned, and some of the others who have been convicted are pursuing challenges that said that their convictions were not valid, including those who pleaded guilty. When David Hicks, who was an Australian man, pleaded guilty in 2007, I went to their lawyers and I said, but you consider this a kangaroo court. Why are you granting legitimacy or conferring legitimacy on this court? And it was explained to me that as the lawyers, their first duty was to get him out of Guantánamo Bay, and the rest would be dealt with later. And this would become the leitmotif of military commissions in the years that would follow, using the commissions to get people out of Guantánamo Bay. Fast forward to today, there are 6 men in capital proceedings facing death penalties, for which the defense is trying, first of all, to get the death penalty off the table, to have them acquitted and or released. But getting them out of Guantánamo Bay is not the priority. For the rest of them, they have used guilty pleas for that specific purpose. Today, there are 4 cases being pursued at Guantánamo. The one Tony represents, which is the USS Cole case, Saudi man who's accused of plotting the bombing of the U.S. destroyer Cole at Yemen in 2000, before 9/11. And one of the debates there and discussions is whether we were even at war at the time and whether this is the correct venue. But that is the case that is closest to trial, and you'll hear about that. The other case that makes Guantánamo probably the most famous is the 5 men who are accused of plotting the 9/11 attacks. That is also a capital case like Tony's, but they are in the midst of negotiations to get the death penalty off the table in exchange for guilty pleas that would allow a military panel, which is what presides in the punishment and findings phase of these cases, to get them life or less in prison. There's 2 other cases. One is the case of a Iraqi man with Afghan citizenship who was admitted, convicted, pleaded guilty to being a Taliban commander, and his case is yet to be sentenced and could be upended because a big key part of it is getting him out of Guantánamo Bay. The negotiation is for this man to find a country to take him because he's quite ill, requires complicated surgery that has not been successful repeatedly at Guantánamo Bay. And the last case are 3 men from Malaysia and Indonesia who are accused of plotting the Bali, roles in the Bali bomb. And that case is brand new. It's only been at the core court for 3 years. And that's what we have. What I wanted to explain is there are no trials at Guantánamo currently. We have pretrial hearings. What's going on in these pretrial hearings is that the lawyers are trying to create the best condition for the fairest trial for these men, all of whom were disappeared into the dark sites, the black sites of the CIA between 2002 to 2006 and 7. Some of them spent 3 or 4 years in CIA custody before they got to Guantánamo Bay. And what happened to those men and what the lawyers can and cannot know about that, and what the lawyers can and cannot tell the public about that, is front and center at pretrial hearings. There are no trials, hearings. And then I'm going to do an observation before I kick it over, which is from where I sit as a reporter and not a lawyer, there's 3 kinds of law that gets practiced in military commissions. There's criminal defense law, which you all know. And Tony sort of exemplifies that. But there's also human rights law, which is to try to bring forward and to articulate why they have to be in Guantanamo in the first place, and the trip they took to get there, and whether this court can be, let's say, legitimate, which is a defense argument. But the third kind of law that people are practicing that they don't talk much about and they maybe don't acknowledge is contracts. Much of what goes on there is trying to negotiate a way out of Guantanamo through a plea agreement or other mechanisms. And so less and less, this is a criminal trial case. These are criminal trial cases, and more what's going on is deal making behind the scenes. And I was just going to say one other thing, which is for the future people who might be going as observers to these hearings, I would urge you to go prepared, read the briefs, read the transcripts. What they call non-governmental observers are used as, one might say, props in a transparency talking point about how this remote base has opened up the trials and the hearings to the public. And you go there for a week, and if you don't read the motions and you don't have a grasp of the case and you don't know what's going on through the triple pane glass, it is very hard to contribute to the significance of that transparency. If you go, you should ask your host for the dockets, you should ask them for the motions and the relevant filings, and you should go prepared. Because to sit there and try to understand what's going on in these phases of the pretrial hearings without having forced the host to give you the documents you need to understand the proceedings is to really diminish the important role you could play as a non-governmental agency. And that's my 2 minutes.
Thank you very much, and I think that's good advice to any lawyers who are going to be observers. One lawyer who has been an observer is Jodie Blackstock, who was in Guantanamo last October, and of course, as the author of the report, Jodie's going to summarise the trial observation findings that she observed while she was there. Thank you, Jodie. You're on mute.
I am going to, but I think it'd be helpful actually if we heard from Amanda first, given that she went to do her observations before I did mine, and can probably talk about the chronology ahead of me. All right,
we could do that. Hi, Amanda.
Hey,
yes, Amanda was in Guantanamo in 2020, I think. So, and also produced a report which is available on the BHRC website. Thank you, Amanda.
Not at all. So myself and my colleague in Chambers, Jacob Beinman, went to observe some of the pre-trial hearings in the 9/11 trial, in which there are 5 accused. And I think both of us were very quickly aware of the practical problems that the joining of the 5 cases together was causing. And we'll give you one example which gave rise to quite a lot of difficulties, and that is because of the length of the pre-trial process. Not all lawyers that are appointed can stay in indefinitely, and the defence teams are made up of military and non-military personnel, and we certainly got to see the practical difficulties of what happens when special trial counsel, who's the civilian qualified to undertake a death penalty case, reaches the point at which they're no longer able to participate in the process and be the assigned counsel. That means alternative assigned counsel has to be found. We're a long way down the line. There's a lot of reading in to do, and that's just one very obvious problem that arises when you've got 5 accused all being held, all being tried together in this very long and protracted process. So there were lots of issues around the kind of procedural problems that arise when you're dealing with a novel jurisdiction, which this is. And they're all being worked out in real time as the pre-trial process goes on. And obviously, a lot of them are focused on issues like disclosure and disputes over admissibility of evidence, for instance, evidence obtained by torture. But our focus as members of the Human Rights Executive Committee of the Bar of England and Wales was to really look at what impact international legal principle ought to be having on these proceedings, and the extent to which the process in the military commissions was compliant. And we identified in our report, which is available on the Bar Human Rights Committee website, 6 key areas where international law did bite on the weaknesses in the process. The first of those was obviously the primary issue around the prohibition in international law on the use of evidence obtained by torture, including confessions. And obviously, the US is a signatory to the key international instruments, including the UN Convention Against Torture, and ought to be concerned in ensuring that evidence obtained by torture is deemed non-admissible. And I think I ought to say there that that extends to evidence tainted by torture, and I think quite a lot of disputes certainly in the 9/11 processes that we saw engaged the extent to which evidence was or was not tainted by torture. The second area of international law that we were very concerned to see the application of was the impact of the death penalty on the process. And we noted that the United States hadn't ratified the second optional protocol to the ICCPR, but nevertheless, the United States is bound by Article 6 of the ICCPR, which prohibits the arbitrary deprivation of life, and therefore is potentially of relevance to the procedure adopted if the procedure adopted was insufficiently governed by procedural safeguards and therefore didn't have the adequate protections against arbitrariness. The next issue that we had identified was the fact that the presumption of innocence in international law seems to be inconsistent or even incompatible with the designation of the accused in the military commissions as unprivileged enemy belligerents, and how that works, how the principle of being innocent until proven guilty could operate in those circumstances. And then the use of classified evidence. We noted that although some of the defence counsel, being military, were security cleared, it seemed to us that there was not a sufficient degree of equality of arms, in that we noted through the process some points at which it was clear that key information had not been disclosed appropriately to the defence teams. And then the last issue was delay. Obviously, a very serious delay in the context of the protracted pre-trial processes in the military commissions. Justice delayed is justice denied, of course. And so for those global reasons, we were concerned to identify those anomalies within the process and give a flavour of the extent to which observation of the proceedings in the military commissions illustrated the lack of consistency with those basic fundamental international principles. So that's really all I had to say. The report goes into a lot more detail, and I understand that Jodie's going to pick up now and speak a bit more about her more recent observation of the Nashiri pre-trial processes.
Yes, thank you. Thanks a lot, Amanda. And yeah, we'll move on to Jodie now. And a more recent report gives me a chance also to advertise the BHRC website, where you'll find all kinds of exciting human rights reports and issues covered there. But we'll move on to Jodie and keep on the theme of Guantánamo, of course.
Thank you, Steve, and thank you, Amanda, for setting the scene so well. I want to just start by drawing attention to a statement made by the joint UN experts on the 18th of January 2023, the special rapporteurs, which said that 20 years after the first detainee was housed at Camp X-Ray in Guantánamo, Guantánamo Bay is a site of unparalleled notoriety, defined by the systemic use of torture and other cruel, inhuman or degrading treatment against hundreds of men brought to the site and deprived of their most fundamental rights. They also said Guantánamo was a profound symbol of the systemic lack of accountability for and censorship of the practice of state-sponsored torture and ill treatment, and the unacceptable impunity granted to those responsible. And that is the background to everything which happens at Guantánamo. And my impression being there for a week, when I was able to see 5 days of pre-trial hearings, submissions and questioning of witnesses, was that really defending these cases is like trying to defend someone with a blindfold on and your hand held against your back or behind your back, because of the difficulties that Amanda's already touched on, and the constant presence of knowing what these people have been through, despite now going towards trial. As Carol has said, for the few who remain on trial. Indeed, there are others there who aren't even on trial. So the difficulties, it seemed to me, in trying to represent someone who is at Guantánamo facing trial is difficulty of obtaining any evidence, difficulty of challenging that evidence, the difficulty of accessing your client and taking instructions or even trying to mount a defence after the passage of time, and the health difficulties that those people now sustain, both physically and mentally, after so much time and after such torture, and the language and cultural barriers. So all of those things I imagine are incredibly difficult to deal with, and I'm sure we'll hear from the lawyers further around how they manage those difficulties. As Amanda set out there, of course, from our perspective, are a number of international fair trial issues that we were assessing the trial against, and I've obviously seen the same ones as Amanda has, that I haven't written them down in the same order, which makes it slightly confusing if any of you have written your notes. But it seemed to me fundamentally, the first one is the right to be tried without undue delay. And the passage of time in Mr. al-Nashiri's case, like all of them, is remarkable, because the criminal acts for which he is accused took place in 2000 and 2002. And he wasn't even indicted until 2011. But 2011, of course, is now 12 years ago. The indictment is for terrorism-related offences under military law, not civilian law, which encompass a whole litany of conspiracy and direct murder, manslaughter, and other treachery, perfidy kinds of offences, which you'll see set out in the report in more detail. And those, why does that matter? I suppose, and of course I should say that certain of those crimes obviously hold the death penalty, and therefore this is a capital trial, which raises, or will be if it gets to trial, raises obviously significant issues in terms of the heightened level of scrutiny that's supposed to be applied in death penalty cases, while Human Rights Committee condemns the use of the death penalty in any case. But as Amanda has said, in the US context, that has to be applied without arbitrary application. And we do express concerns about that in the context of the presumption of innocence, which I'll come on to. But the passage of time is obviously a problem in terms of the memories of any witnesses that eventually might be found, and I'll come on to why that's an issue in this case. But also the personnel. There have been 5 judges, as I understand it, in Mr. Nashiri's case so far, and multiple changes in the legal teams because of that passage of time and because of issues that might arise between those personnel and views that they hold or things that have happened. And I've set some of those out in the report, which in themselves are quite remarkable, really, as to how this case continues in the wake of those issues. And secondly, the presumption of innocence then. The jurisdiction in this case is an odd one, because in order to be tried in the commission, you have to be an alien unprivileged enemy belligerent, which is essentially someone who's engaged in hostilities against the US or coalition partners, someone who's purposefully and materially supported those hostilities and was a member of Al-Qaeda at the time of the alleged offence. These offences relate to incidents which occurred in Yemen. They do relate to a US warship, but it isn't clear whether the jurisdiction of the military commissions even should apply to this case. And yet we are 12 years down the line without that decision having even been made. It's in the report that our conclusion, perhaps cart before horse, in relation to everything that's happening there. The third issue is perhaps the most important and unique in Mr. Nashiri's case, because this is the right to examine the witnesses against you. And I spent 5 days watching the pre-trial process as to whether hearsay evidence will be admitted in his case. And it seems, having watched the process of examination of the US agents that were sent out to investigate these acts to Yemen, that the entirety of that evidence is born out of notes made by FBI agents. So that is double, if not triple, hearsay. There are no witness statements. They're not signed by any witnesses. It's not clear where these witnesses have come from, whether any of them are in fact who they say they are. Doesn't appear that any particular work was done after they gave their interview to the US agents to check anything of what they said, the veracity of what they said, or follow up on anything of what they said. They were brought in by the Yemeni special police, who were tasked with investigating the bombings, who themselves were notorious at the time for their methods of investigation and interrogation. And that in itself raises questions about the veracity of these witnesses' accounts. And none of these witnesses have verified the FBI notes that were kept about them. And it may well be that they, if they were given the opportunity, would disagree with some of what was said or attributed to them. And there are, I think off the top of my head, I haven't got the number here, but something like 116 witnesses, thank you, Tony's nodding, all in the same boat, all taken from FBI notes. And that is the case against Mr. Nashiri, coupled with an extremely odd and dubious photo identification procedure, which perhaps, if we have time, we can go into. But on the first day of the hearings that I saw, involved the wrong person being identified for a start. So there was confusion about how this photo book had even been prepared and who was whom in the pictures. Never mind anything else about the fact that Mr. Nashiri was a composite picture amongst other pictures that were not. Obviously, the fourth thing, evidence obtained through torture. There's other significant pre-trial motions in place about whether evidence obtained can be relied on, which the defence says is tainted by torture. This is evidence obtained after 4 years of torture with a 6-month break, and then what is defined as a clean team. And suddenly it's supposed to be suggested that any evidence, confession evidence then given by any of the men is reliable against each other and against themselves. And the final thing to raise is really the right to know the case against you, and the fundamental ongoing difficulties with transparency and with disclosure, and the immense difficulties I understand that there are obtaining all of the documents in the case. And sometimes those documents come from discovery in the other trials, and other detainees who are on trial in the context of the KSM case, 9/11 case, or in the context of other proceedings. And it's only as a result of conversations between the lawyers that it emerges that some of that evidence exists. And that's clearly not the basis upon which you are able to mount a proper defence. So for those reasons and others set out in the report, we concluded that if the evidence from these hearsay statements and torture evidence were to be relied on, it seems impossible, plus the other reasons, for a fair trial to take place in Mr. Nashiri's case. And of course, we are as yet nowhere near trial. Thank you.
Thank you very much, Jodie. That's fascinating snapshots from two of our lawyers who've been and observed at Guantánamo. And I think along with Carol's background information as well, that gives us a really good platform to move on to the next stage of the session this evening. I'm going to move on to a Q&A session with Wells and Alka and Tony, and I'm going to ask you some questions as to for your experience of working on these cases for many years, how your views on some of the issues which arise. I'm going to start off with what might be a big question and just ask for a few thoughts from all of you. And for all of you, do you consider that there's any possibility of a fair process in the military commissions, having heard what, especially having heard what Jodie and Amanda have been saying? Perhaps I'll start with Alka on that one.
Sure. There's a very short answer to that, and the answer is no. There has never been any possibility of a fair proceeding in the military commissions, primarily because the military commissions were set up exclusively for Muslim non-citizens who were brought to Guantanamo following illegal proceedings. And it's the rules of the military commissions come entirely from a purpose-written statute that is meant to slant everything in favor of convictions, right? I mean, there's a reason that the legal complex at Guantanamo is called the expeditionary legal complex, because there were supposed to be very quick trials pursuant to this statute, very quick convictions, and presumably very quick executions. And so there's a reason the rules are written such that even though someone alluded to inequality of arms, we all have the same security clearances, defense and prosecution alike, but the prosecution gets to withhold enormous amounts of relevant discovery in death penalty cases pursuant to the statute, and they get to claim national security, right? And then we spend years and years and years trying to pry out bits and pieces of information that ends up being central to the defense, right? As we've learned through the 9/11 case. And I think Nashiri is a great example of that as well. And so, no, there's no possibility of a fair trial. There never was. And that, it's just gotten worse over time as medical and other issues impact the proceedings.
Thanks. I'll ask the same question to Wells.
Thank you, and thank you for having me today. I will say I agree completely with Alka. I think it's important to remember that the military commission system was not set up to ensure a fair process, and quite the opposite. Alka is correct, and Carol is correct in talking about the original purpose of the commissions to obtain swift justice by denying fundamental rights, in particular the right to confront one's accusers. And it was in that context that a lot of the initial military commission proceedings really went nowhere with the exception of guilty pleas, which were used as a vehicle to get out of Guantanamo, certainly in David Hicks' case, in the Omar Khadr case as well. That was the child from Canada. I do think, though, the situation changed a little bit in September 2006 when the so-called high-value detainees were transferred in from CIA detention. At that point, I think the commissions began to serve a somewhat different purpose, and that was to really maintain the status quo. And what I mean by that is the commissions were used to provide a thin veneer of legal process, but really a process that would do nothing except keep the men in detention and keep them largely incommunicado, so they couldn't talk about what had happened to them or who was responsible or where it had happened, right? They couldn't talk about CIA torture. And that was, and I think continues to be, the sole purpose of the military commissions now. I don't think that there is any possibility that any of these cases will go to trial. I think the purpose of the commissions is to keep the men incommunicado for as long as possible. And with that understanding, I think a lot of what's going on in these trial proceedings becomes perfectly clear when you talk about secrecy. And I think for us as defense counsel, our defense strategies become clear. When you realize that everything that happens in a military commission, everything is designed for one purpose, and that is to prevent information about CIA torture from becoming public, right? When you understand that that is the only purpose, it makes it crystal clear what your job is as a defense lawyer, and that is to get the information out, right? It becomes sort of clarifying. And my recommendation for observers who go to Guantanamo now and watch these proceedings, which I very much support and encourage, is to really pay attention to what's happening, right? To take a step back and, yes, there'll be arguments about hearsay and there'll be arguments about confronting witnesses, but take a step back and really look at what's going on. And it is a push and a pull between concealing torture evidence and exposing torture evidence, right? And when you get close to exposing torture evidence, and I don't mean leaking evidence, I don't mean anything like that. I'm talking about through a legal process. That's when, as a defense lawyer, you can obtain results for your client at this point. There are some examples of this throughout the commission's process, but really pay attention to what is really going on. And I think a lot of the correct and true criticism of the military commissions are understandable when you realize that.
Thank you very much. Have you got anything to add to that, Tony? I just need to take yourself off mute, I think, if you can, Tony. I think we'll come back to Tony if he's having problems with his IT there, and perhaps I'll ask you both follow-up questions to that. So I'm not sure what the answer will be given your response to the last question. What changes would you make to make the process fairer? Is that possible? Is that something which can be done? Okay.
There's no way to make the process fairer, the process as it is now. There is a way still, there are several ways to correct some of the crimes that have been committed by the US government. And those include, resolution of the cases. That includes providing medical care to the torture victims who are at Guantanamo, who've not received proper medical care for their torture, that's 20 years old. But I don't believe there's a way to make things fair. I see Tony's come off of mute.
All right. Well, perhaps, Tony, I can ask you both those questions in that case. do you think that there's a possibility of a fair process in the commissions? And if the answer is no, what changes would you make? What changes would you propose to make it fairer?
Well, I would sort of like really, I'm in heated agreement with what everybody else said. The system is so perverse that anyone seeing it, they scratch their head because they can't believe what they're seeing and hearing. That's how distant it is from any notion of due process. I'm not going to repeat what other people said, but you basically have a system that is doing exactly what it was designed to do. And I think Wells points out as defense lawyers, the better defense lawyers they have, then the more constitutional challenges we're going to make, the more litigation will take place, and the longer everything will take to resolve. Because as we all know, the government takes the position that the Constitution doesn't apply. So what could help there? Nothing, unless they were to say, look, we've got to end this, and let's not go through with the charade of anything that would resemble due process. It's important to understand that the judges, and I know, I have all my ethical obligations, and I would not want to demean any of the fine people who serve as judges. However, none of them have any experience in handling death penalty cases. None of them have any experience in really dealing with questions of international law. And many of them have had very little, if any, real trial experience. And you have a system, and I think, Elker and everyone pointed this out, there's no law. Actually, it was Amanda pointed this out. There's no law for these people down there. It's all, try this case, try that case. But all of the cases that you cite, be it military jurisprudence or regular civilian jurisprudence, was predicated that there's a constitution that applies. So what you have is, in essence, a lawless system where they try to put the thinnest of veneers on things. And you have judges who are not independent. In the very beginning, if they were to put regular Article 3 civilian judges, that would have been a great improvement. Now I think it's too late. And what we have is a systematic and continuing fight to expose what was done to these people, to expose how they're currently being treated, and that how those two things are inextricably joined as part of the strategy, and that the protection of the CIA is first and foremost. And the hope, I think, is that people won't care and it'll be forgotten. And which is why I'm very grateful and thank you for this invitation, because it's still going on and it sets a horrible precedent. And I applaud your efforts to be involved and to try to exert whatever influence you can do.
Thank you so much for that answer, Tony. Wells, if you've got anything you want to say about what may make it fairer, then that'd be great. But I also wanted to ask you what impact has litigation outside of the military commissions and the publication of reports such as the CIA torture report had on the process inside the commission?
Well, I think that reporting from outside the commissions is very, very important, both because it's important to educate the world about what's happening at Guantanamo, but also because, remember, this is not a real court. And I'll say, as a defense lawyer, I can use those reports as evidence. So, it's very convenient. What's good for the government's good for us as well. And it creates this unusual situation where, really what's happening is a bit of theater. And so, I'll say that. I do want to say something with about the military judges, and I'll say that in my experience, the judging has been mixed. Certainly, there are a number of judges who have left a lot to be desired. And I will say, though, in my case, we've had some very good judges, and I'll also say that. There was, I think, an assumption when the high value detainees were transferred to Guantanamo in 2006 for prosecution, there was an assumption that the military would go along with what the CIA had done and would cover up what the CIA had done in terms of torture. And in my case, at least, that wasn't so. In the case that I had that went to conclusion, we had a military judge who looked at what had happened to my client and said, that's torture as a matter of law, and wrote a 42-page opinion citing human rights reports and human rights instruments and customary international law. And that created, that was one of the very, very few times in the post 9/11 world where there was a real threat to the CIA that it would be exposed, right? And it would be held accountable for what it had done to these men, and there had been times before. You mentioned the Senate Intelligence Committee report where it was looking as if perhaps the CIA's secrets might be exposed. Those were instances where the CIA was able to sort of manage through its bureaucratic and administrative and political powers the information that came out. But when it came to my case and to a military judge who said this is torture, that was I think really the first time where there was a real risk, and it was that risk that generated results that got my client out of Guantanamo. I think it's important in that regard. And it was a military jury comprised of senior military officers who said, in the case of my client, that what he experienced was torture equivalent to the worst regimes in history. So you had a repudiation by senior military officers of what the CIA had done. And I think that's important because it undercuts this initial assumption that the military would go along with what the CIA had done. But again, having said that, I think the experience in commissions is the judging has been very, very mixed. My client was just lucky.
Thank you very much. Really interesting. The next question I want to ask is for Alka and Tony, and it's what impact has the availability of the death sentence had on the defence's tactical approach? Perhaps Tony first.
Well, when you have a death penalty case, one of the first and most important things is developing the relationship with your client. And then is being able to do the proper investigation of mitigation and to get to the bottom of what is this case really about. And what happens here is that you can't do those things. They may, as the way you normally would. You can't just subpoena witnesses and they get to be called like they would in a normal court. You can't just go and interview people because they are protected because of their prior involvement with the torture. So you have all of these things to do, but not only to do them, you have to litigate and fight to get the chance to do them. And it has been difficult to get the notion of death is different and that there is supposed to be a heightened sense of reliability. There may have been some judges who have accepted that, and that's to be applauded. However, the government's position, is that that only relates to sentencing, and it doesn't relate to anything else. And that, you know, they've taken positions where due process, whatever due process the Constitution would say they should have, they have, but they don't want anybody to rule on what the Constitution says. So, and yet you want to take someone's life, and it causes you to fight harder and more, but you are frustrated, and it's hard to develop the relationships with your client because of the whole system.
Thanks, Alka.
Yeah, I mean, so I think, you know, Tony addressed a lot of points there, and he's absolutely right. And I would say all of them apply in the 9/11 case as well. On the due process issue, you know, obviously the Constitution ensures due process for everyone. And it has been a struggle to get the tenets of due process applied at Guantanamo. And we're actually in a fight currently over whether or not the due process clause of the Constitution applies to Guantanamo Bay detainees in the al-Hila case, which is currently up, I think, is it up at the circuit? Yeah. I think circuit at the moment. And a number of us wrote amicus briefs on that. But, you know, we managed to pull out, you know, habeas corpus in 2008, which has been steadily chipped away since then, but nothing else. We're in a position in the 9/11 case, and this may be true in Nashiri as well, where every motion that we write, we say, hey, it's a death penalty case. We're relying on these Supreme Court precedents. We're relying on due process. We're relying on, you know, all these constitutional protections we should have. And the government will file their briefs saying, well, you know, if it were applicable, you know, it wouldn't be, you know, we would still argue against it, whatever. But there's no military judge has been willing to rule on whether or not these provisions of the Constitution apply in a court over which the US flag flies, right? Which I find just appalling, even now, years and years later, you know, and this manifests in, the government, when we talk about due process and the death penalty, right? One example of that is we are entitled to all relevant information to the defense. And that is very expansive under the Constitution. But when you try and apply that in the military commission, when we came in, you know, guns blazing in 2012, saying, all right, give us everything about the RDI program, right? We're security cleared. The government said, no, that's not relevant. That's not relevant. That's not relevant. Hey, give us information about FBI involvement in the torture program, right? Because it wasn't just a CIA program. And then from 2012 until 2018, we were told explicitly by the government over and over and over again, this is a wild goose chase. The defense has no right to this information. And by the way, there's no information. Nothing exists about this because the FBI wasn't involved. And that was a bold-faced lie, right? To anyone from DOD or CIA or FBI listening in, right? It was just a lie. And then we found out in 2018 and have gotten drips since then, including like 2 weeks ago, about the extent of the FBI's involvement in the CIA, you know, administered black sites, right? Which puts to rest the question of whether or not this is torture tainted or torture acquired evidence. It is all torture acquired evidence. There was no attenuation to any of it. So, you know, that gives you an example of how long this takes in, you know, in a death penalty case where we should have had all of this information from the beginning.
Thank you very much for that. One question we've touched on already, and I think for some people might be a bit of a surprise that it's a real issue, but I think it'd be interesting to explore it a bit more. How have medical issues such as access to doctors and psychologists for the detainees impacted the proceedings? Perhaps I'll start with Wells on that one.
Well, I begin by saying two things. One, I think as Alka may have said, you know, all of these men are seriously damaged at this point. They arrived in Guantanamo seriously damaged, and Guantanamo has only made that worse. And so that's a reality that we have to contend with and work around to the extent we can. The other thing I'll say is that there is absolutely no therapeutic care of any kind in Guantanamo. It does not exist. And so we often find ourselves having to deal with issues that, at one point may have been small, but have become serious, significant issues, or more significant or serious issues, given the lack of therapeutic care. It is a real problem, and one that needs to be dealt with. I mean, I don't know what else really to say about that. But a lot of it again derives from really what is the bottom line with respect to all of the military commission proceedings, and that is it arises from a refusal on the part of the U.S. government to disclose anything about what happened to these men or who's responsible or where it happened prior to their arrival in Guantanamo. And so, limitations on medical records, on even understanding what happened are the consequence of that. It's very, very challenging.
Thanks. I think it was you, Alka, who raised it before. Is it anything you want to say about it, this issue?
Sure, just briefly. I'm sure I know Tony's nodding along as well, because I know Mr. Nashiri has his own issues. But look, I echo everything Wells said. There is no medical care at Guantanamo. The DOD is still out, putting out press releases and saying publicly that the detainees have better medical care than service members do. And again, that is a lie, right? Service members who have problems at Guantanamo that cannot be addressed by the hospital are airlifted off island. The detainees are not allowed to leave island. And so we are literally one disaster away from, God forbid, a death at Guantanamo because of the absolute lack of care for detainees. My client has multiple traumatic brain injuries. He has deteriorated measurably and visibly in the almost 8 years that I've represented him. And he just cannot get, it is a fight to get just basic sleep study or MRI. The MRI, as Carol has reported for years and years and years, right? The MRI is this long running saga that eventually someone will make a movie about, and perhaps Scarlett Johansson will play the MRI that just keeps dying. But it's appalling. We recently had 4 NGOs in December, the Association for the Prevention of Torture and Amnesty, the OMCT, and the International Commission of Jurists, who said straightforwardly, the continued withholding of medical care by the U.S. government at Guantanamo Bay is an active commission of torture. It is an active violation of the Convention Against Torture. And so, it is not just that, hey, torture happened and ended in September 2006, right? It continues to this day at Guantanamo.
Thanks. Tony?
Absolutely true. I mean, it is barbaric what is going on. And it's easy for people to say, well, it's difficult. No, this is barbaric. And it is not different. This is part of the program from when it got started with the RDIs to now. Everything that they are doing, not providing the medical treatment, everything is consistent with their plan of how they were going to torture and treat these people. It is mutually reinforcing, and you have to fight to get medical records. And when you do, ordinary medical practice is discouraged, if not prohibited, by the medical people there. What I mean by that is normally a patient's history is one of the best things that you can use in forming a diagnosis and a treatment protocol. They can't ask that. They're told not to ask that. We don't want to talk about that. So it is so horrible that, you sort of think that, and it's been protracted. And yet we're fighting it. We fight it every day. But there hasn't been the outcry that there should be, even within the medical profession. Medical profession should be going wacko over these people. I'm not as eloquent as everyone else, But it's obscene. It is. But those of us who like to fight, that's what we're doing there. And people like you are giving us additional ammunition and motivation. And our clients, we tell our clients that.
Thank you. Lawyers who can say things are wacko are my kind of lawyers. Thanks for that insight. The next question is more of a technical question, I think, and it's what are some of the advantages and shortcomings of having security clear defense advocates, for example, in terms of access to classified evidence? I'm going to leave it up to you to decide who's going to answer that one first. Perhaps I'll stick with Tony, as he's not on mute at the moment.
I think it's great, because at least you can get something, and you can then begin to put together pieces and use one thing to another. And we have our the secret proceedings, the cone of silence and all that other stuff. But at least there is a mechanism to try to litigate some of these. But you have to be very, obviously you have to be very careful, because we're not the press and we have restrictions. But it does give us an opportunity to defend our people better than we would if we didn't have the clearance.
Thanks. Wells?
I agree. I think on balance, it's a good thing. First and foremost, because it's a requirement in order to go to Guantanamo and meet with the men who are detained there. We don't have a clearance, we can't go and meet them. And so it's a necessity. And it does give us access to more information. You can sort of learn more about what's happened, and then that can inform kind of your strategy for how you're going to use that. But I also agree, it is a very serious business, and as much as Tony and Alka and I, criticize the commissions and are, aggressively, we're also very, very careful, and we take that obligation very seriously. It's not to accept the system, it's not to accept the classification, it's not to accept the secrecy around Guantanamo, it's to ensure we can continue to do the work.
Thanks. Alka?
Yeah, I mean, I obviously agree with both of them. I will say, it is a double-edged sword. On one hand, the men themselves are classified, right? I mean, they were, yeah, they are. They're classified people. They're like, I think Amar recently, we were talking, and he thinks of himself as a relic in a classified museum, right? Essentially, that only a few people can get to. So you need it. You cannot build a relationship without it. You cannot defend these men without it. But the other side of that is that we're very limited, right? And this is limited. This, Tony, saying wacko and me calling proceedings a goat rodeo, right? That is limited in what we can say about the excesses, right? Or the crimes being committed at Guantanamo. There is only a very small, as much as we talk about the SSCI report and the torture program, that is only a small fraction of the information we actually have access to, right? And that information that we have access to is only a fraction of what the prosecution has given to us after getting permission from the CIA. So imagine the amount of information there actually exists about the CIA torture program. So it is difficult, and we have to draw very fine lines in what we talk about with the security clearances. I do just want to say that, sorry, I do just want to say that that Carol has actually written a lot about the secrecy issues in the court, and from the other side of it, right, about how difficult it is to get to write some of these stories and to understand what goes on at the military commissions with all of the classification.
Thank you. Well, I think we'll come back to Carol in just a moment, and I'll ask you about that. I did just have one last question for our lawyers panel, and it's one I think which is an issue which faces all lawyers acting for clients in what are perceived in unfair and unjust legal systems, and probably to an extreme extent in the Guantánamo process. But it's this: is if you think there's no possibility of a fair trial in this process, do you risk legitimizing it by continuing to act? And I know that's a tricky question, but be really interesting. I'm sure our audience will be really interested to hear what you've got to say about that. Who wants to start?
All right.
Thanks, Tony.
Stephen, is a profoundly significant question. It raises significant ethical, moral issues, spiritual issues, as well as legal issues. And I think that it becomes a personal decision for people, but you also have to make sure that there's an honesty to it, and that it isn't a tactic, that if you don't participate, then you stood silently by. That doesn't work for me. There's always like, if everyone said we're not going to represent anyone, what would they do? They'd find somebody, and these people would have been already executed. So, but it's a tough question. My feeling is, I fight until I'm too old. Be creative.
Thanks. Thank you very much. Alka, that question you want to answer? Cool.
Yeah, I think from a human rights perspective, which is how I've always come at it. I don't have any conflict in doing it and being so-called part of the system. I think it does. I mean, primarily because these men need advocates, right? No one gets to them if we don't participate in some way, if we don't sit there and get the clearances and go through the interviews and make time to go to Guantanamo, right? And spend significant chunks of our lives. Certainly, I know Wells has been there. Wells and Carol have logged the most hours there of the lot of us, but men have no one otherwise, right? They don't get family visits. They don't get medical care. We are like essentially everything to them. So from a human rights perspective, it's absolutely necessary. That said, because you are technically then part of the system, I think there is a heightened responsibility and obligation to get out every piece of information you can about the place, every single scrap of information that that the public should know about it. And we don't break classification rules, but we work very hard on getting things declassified and making sure the public can see it. And you all play a very important role in that as well. And so we're very grateful for that.
Thank you. Same question to Wells.
Yeah, so I'll say this. I've represented a lot of detainees at Guantanamo, and I've really only ever had one singular goal, which is to get them out of Guantanamo. And, it may sound somewhat Machiavellian, but I'll use whatever means or process or procedure is available to do that. And military commissions, in my experience, for my clients, and again, I don't represent any of the capital defendants. So in my experience, commissions have just been a tool or a vehicle to get my clients out of Guantanamo. I've never really thought of the military commissions as legitimate. I've never had that expectation. I don't think my clients have ever had that expectation. And so I haven't worried about the legitimacy of the system. Legitimacy is irrelevant, simply a means to an end, which is to get my clients out. So
yeah. Thank you all so much for sharing that with us. I think a lot of the people listening in will be inspired by your answers and your commitment, and also the insight you've given to how the system works has been fascinating, thought-provoking, and it's really important for us all to know what goes on at Guantánamo. What I want to do now with the last few minutes of the session we've got left is bring Carol, Amanda, and Jodie back in, and we've just got a few more questions, some from the Q&A. But I thought, Carol, I'd come to you first of all and ask what impact has journalists and NGO scrutiny had on the commissions, and how this scrutiny has changed over the course of your reporting. And I think the issue was also raised about the problems that journalists have in getting access to information. It'd be interesting to hear something about that as well.
What I was going to say previously is to be a journalist at Guantánamo is to ask a defense lawyer a question and to be told, I can't answer that because the answer is classified, and that you do that all day long. And you hear things, you read things, you know things, they've been published in the newspaper and they can't talk about it. And so, and you know, they have to keep their clearance and they have to stay out of prison. And I'm not begrudging them, but you have to understand how often I know a fact, they probably know the same facts, but they can't talk about it. So that was the first thing I was going to point out. And then in terms of scrutiny, I went to Guantánamo in January 2002 because I had an editor who said they were going to build a prison out of reach of the American public and out of reach of the American courts. You know, prisoners didn't have lawyers for the first 2.5 years there. They didn't have lawyers. A man in the Midlands by the name of Shafiq Rasool had a case that went to the Supreme Court and won the right for detainees, I'm talking about uncharged people, to see a lawyer after 2+ years of detention. So my editor said if they're going to keep them out of reach of the American people, out of reach of the American courts, they were not going to keep it out of reach of American journalism. So we asked the questions that need to be asked, and we publish what we can, and we don't ignore the fact that there are still 30 men down there in an operation that was set up 23 years ago as an experiment in offshore detention and now extraterritorial justice, and covered incrementally, and somebody should do it. And so for whatever reason, everybody else went home and I stayed. The impact, somebody has to ask questions. And it's the same thing when I urge the NGOs to, and this is with all respect to the people who go there, to drop in for a week is really hard. But the one thing you can do is push and push and push them to give you the motions that are going to be argued and to have access to what's going on the other side of the window that in the 40 seconds ahead of you. Because frequently we go down there and we can't even read the motions because somebody hasn't cleared them. So it's the basic fight for transparency that the NGOs can contribute to in ways every minute, all the time. And that's all.
Thanks. I think now would be a good time just to bring back in Jodie and Amanda, who are two people who've been there for a week and experienced, as I said before, a sort of snapshot of what's going on there. I mean, for both of you, and perhaps Amanda first, how did your experience of observing at Guantánamo differ from your expectations?
Well, we have a very different system here on the use of special advocates. I mean, the key thing is that once they've seen the closed material, they can't communicate with the individual. So that makes a very big difference to their effectiveness. And I was very interested to hear about how the system in Guantánamo is used to facilitate what all advocates today have said is a better, not great, not conforming with the usual norms, but a better way of being able to represent those individuals, because they do have sight of the closed material and they are able to sort of press it into service. And like the advocates here, I think it was clear that, having met with the defence teams, that you develop a certain amount of being able to read the runes. Once when you can read what's not there sometimes, and the longer you do it, the better you get at doing that. But there were two things that struck me about the sort of chimed with my experience. The first, that Wells talked about how you can, when he's been able to secure a good result, it's when he's been able to use the disclosure process and take it as very far as you can, because like here, the government makes a calculation. If they know the court's going to order disclosure on something, that's when you're going to get a concession out of them. And I'm certainly familiar with that as being sometimes the only way it's possible to secure a result for a client. But the other thing that struck me, and it still strikes me today, and I wasn't expecting this, I don't know why I wasn't expecting it, because obviously I had a bleak outsider's view of Guantanamo. I wasn't prepared for the work rate, the diligence, the ingenuity, the skill, the fight, the dogged persistence of the defence teams that I met, and I'm filled with admiration for them.
Thank you very much. Thank you. How about you, Jodie? How did your experience differ from your expectations before you went?
Well, obviously I had low expectations because I'd read Amanda's and Jacob's reports already. But I'd certainly echo what Amanda's just said about the approach of the defence and the professionalism, and just, I mean, I was that person, Tony was saying, looking shocked and appalled in every recess because I just couldn't get my head around what was happening. I think the main thing for me really was the veneer of due process. This is a courtroom with a judge on a dais, and benches allocated in the right places, and witnesses being questioned according to the rules of advocacy. But behind all of that is how bizarre it is to be going through this process of asking questions about whether you can rely on hearsay when the entirety of the case is hearsay. And it's not even hearsay because it's just notes that the US agents have taken in the construct of a system where they shouldn't even have been there investigating in the first place. And we sort of sat there diligently keeping our notes behind our screen of every witness for 5 days, and just thinking, why are we even doing this? And obviously I only saw 1 week of it. You've been doing this for over a year now to get through all of those 116. I mean, there was on the final day, and of course the torture that, Wells was saying that the torture issue is the most important, and the finite details of examining witnesses is neither here nor there. It's because actually it's the torture evidence that's most important. I did see some of that, and the way the government was pushing back against an application. Again, it's hearsay evidence to have someone who has made allegations by way of confession against Mr. Nashiri, who was tortured, and the defence certainly say his evidence is tainted by torture, wanting to use that as a hearsay statement rather than bringing him to court to give his evidence. And the defence motion was, can we just have him here? And the government saying, well, no, you can rely on the evidence he gave in the US District Court trial. There was sort of a moment at the end of that where the judge did say death is different. And I am trying to apply a heightened test of scrutiny here. And I did sort of get the sense that he was at least trying to do something in a system which perhaps even he thought was bizarre and farcical. And there was this sort of moment of a slight loss of temper at the government audacity you know, to minimize how important it was to have a witness there on something so crucial. So yeah, there's this veneer of trying to make something fair that is just fundamentally not fair, I think.
Thank you very much. That's really interesting. We've only got a few minutes left, and I think I'm looking at the questions on the Q&A, and I wonder if we're going to have a quick response from our participants from the States on this question: is whether you see an end game and to Guantanamo, whether there's an end process to it, or how do you see? How is it as the case? I think people have mentioned that it'll just keep on until there are no detainees left alive. I just be really interesting, I think, for our listeners to get your quick views on how you think this is all going to end. I'll start with Wells.
So is there an end game? Yes, there's one end game that I see. And that is for the Biden administration to do what it said it wants to do, which is to close the prison. And now, how do you do that? Well, got a large, most of the detainees are approved for transfer. They could leave, you know, today or tomorrow. And then you have the remaining military commission cases. And I'll say, having no more clients in the military commission system, that to me, as an observer now, you know, the only way to conclude the military commissions and thus to close Guantanamo is to negotiate the resolution of those cases. That is through guilty pleas. You know, I don't take a position on what those guilty pleas ought to include, but I think it's pretty clear that if the cases continue ostensibly toward trial, that nothing will happen. Because again, the commissions were not set up to achieve justice and accountability. They were designed to do and achieve nothing but cover up torture.
Thank you very much. I'll put the same question to Carol. Yeah. Yes.
Well, I mean, to close Guantanamo is to move Guantanamo, to take a certain subset of the population that America will not let go. There is a man down there, so life. I suppose you could get paroled, but I don't know to where. But to close Guantanamo is to move Guantanamo, to pick up the subset of that population and move them to the United States. I would call it Guantanamo North. The United States may not want the prison at Guantanamo Bay, but they do want some of those prisoners. And I do not foresee an end to it. So yes, the president may persuade the Congress to let him move them. And they may end the enterprise that's called Joint Task Force Guantanamo. But the men who were picked up, particularly that came through the CIA black sites, some of them, 3 and 4 years disappeared into the dark prisons of the world, would continue to be held under every scenario I can imagine. Not all of them, but some of them. Closing Guantanamo would probably professionalize it, probably have a better prison in the United States, but they're not going to open up the doors and let those 30 men. And there are people there who are cleared who they can't find countries to take. And yes, they have to work harder and find countries to take them. And I love writing transcripts.
Thank you, Tony.
Maybe I'm cynical, but I think that we're going to need another generation of committed human rights and criminal defense lawyers to carry on when people like me are dead and gone, because they, unless there's an opinion from a court, unless there's an opinion of a court that says this, you don't have jurisdiction or you can't use torture, this will continue, and it will continue, and it will continue, and it will continue. And who knows, that may be part of what they want the end game to be. But, you know, I always tell the other lawyers that are on my team, I said, you know, we're doing something that's part of history. And whether we succeed or not is not the measure. It's how hard we tried and how creative we were and how dogged we were that will speak to a sense of what previously was considered American justice.
Thank you. And Alka.
Well, you know, look, it's not an easy question, right? Do you see an end game for Guantanamo? And Carol alluded to the difficulty in transferring men who have already been cleared for release. That is entirely a problem of our own making, because we put out so much propaganda about these men in the early years that no administration, whether Obama, Trump, or Biden, right, has ever been willing to go back and say we were wrong. That countries now, right, we have to fight with them about the propaganda that we put out about these men. And so countries come back to us and say, why would we take this person or that person when they were, you know, they fought at Tora Bora, or, you know, whatever it is, right? When we can't go back and say, actually, we lied about that, or actually, you know, we you know, gave someone privileges at Guantanamo to tell us that fake information, right? We can't say that. And so we're stuck in a problem of our own making on that. The issue with the cases with, you know, Tony spoke very eloquently just now, and that's in part because for reasons that I don't fully understand, the Nashiri case is not in plea negotiations as the 9/11 case has been for the past year. And the Nashiri case, interestingly, is the one that is squarely out of the jurisdiction of a purported war tribunal, right? The Cole bombing was in 2000, long before any possible armed conflict began. No matter how you judge the armed conflict. And it might be interesting for people to understand that the United States government has retroactively taken the position that the armed conflict began in 1996. So entirely for the purpose of exerting jurisdiction over both 9/11 and the USS Cole case. So, you know, there are all these little parts of it, right? We could make things easier if the administration said, yes, we bought people for bounty. Yes, we made mistakes in the information we put out about them. That is not, you know, that's not accurate information. We could get those cleared guys out a little bit faster, right? At this point, the administration could very, very easily, right, come to a decision on case resolution for at least the 9/11 case. Now, yes, there still remains a problem of if they're guilty pleas, where do those men serve those sentences? And, you know, would they ever be brought to the United States? Would they serve those sentences at Guantanamo, which then might change the character from indefinite detention to, you know, serving a sentence, which there are various opinions on. Does that achieve closure of Guantanamo? Not exactly, but it changes the nature of the detention at Guantanamo in some minds. But all of that, but I want to be very clear. All of that can be done by the White House, right? They don't need Congress for that. And every president, with the exception of Trump, who never made any sense on anything anyway, every president has enjoyed blaming Congress for their inability to move on Guantanamo. And what Congress has done is limit countries that can take detainees, including the United States, right? Which has made things harder. But nothing stopped the Biden administration from coming in on day one and saying, Guantanamo is now closed. We are now transferring people, right? Or the military commissions are over. You know, we're going to figure out the case resolutions. Like, nothing has stopped the White House from doing that, and nothing stops them from doing that now.
Thank you very much. I think that's a fitting point on which to end this this session. It's been absolutely fascinating from the point of view of human rights, the way that human beings are being treated, and also the work of lawyers as well. I feel like we could go on for quite a while, and quite a few issues we haven't covered, and perhaps we ought to have another session in not too long, because I think it's important that lawyers and people know about what's happening, and from the journalistic point of view as well, Carol, as well, fascinating insight into the work of that you and others are doing in trying to bring news of what's happening at Guantanamo to the world. So what I want to do now is bring the session to an end. We have to do that, I'm afraid. Many thanks to all our expert speakers tonight, to Alka, to Wales, Tony, Carol, Jodie, and Amanda. I need to advertise BHRC's trial observation reports again, of course, both of which are on our website. That will be emailed to all our attendees if you've not picked it up from the chat already. Thank you for coming. Thank you for listening to what people have to say. Please do email BHRC if you have any further questions about this and BHRC's other work. We've got a fascinating seminar next week on diminishing democracy in Myanmar, which you might want to pick up. That's on the 7th of June. So that's my advertisement for our forthcoming work. But this has been a fantastic session. I'm very pleased that we've managed to put this on today for you all. All right. So thank you all to our speakers once more, and I'll bring this session to an end.
Thank you.